Good evening, everyone. Thank you for joining us this evening. I am Kimberly Sparks with the Prince William County Human Rights Commission. Before we begin, we have a few reminders so that we can maximize our time with you. As a courtesy to everyone, all attendees will be muted for the duration of the webinar to avoid background noise. We've allotted time for questions at the end of this webinar, so we ask that you post your questions in the Q&A box or the chat box on your right-hand side. If we do not get to everyone's questions by the end of this webinar, our presenters will respond to you individually right after. For those of you who are in need of ASL and CART accommodations, please let us know if you have difficulty accessing the interpreters through the chat box. And lastly, the presentations and all handouts will be provided after the webinar to your registered email addresses. If there is an additional email address that you want information sent, please drop that in the chat box as well. So again, thank you for joining us for the Human Rights Commission's re-entry webinar. And I am going to give the floor to Jacqueline Smith. Actually, we have Jacqueline Smith, our clerk of court, who's going to talk about expungement of records. We have Christopher Alvarez with our Office of Elections, who's going to discuss restoration of voters' rights. We have Mark Cherninsky with Virginia Career Works, who is going to talk about reentry employment resources. And we have Mindy Weinstein, Director of AELC's Washington Field Office, who's going to talk about arrest and conviction records in employment. And so now I will give the floor to our Clerk of the Circuit Court, Jacqueline Smith.
Hi, everybody. Thanks for attending today. I'm here. I am the clerk of the circuit court for Prince William, Manassas, and Manassas Park. And a big part of re-entry is, of course, trying to clean up your record as much as you can. So I'm going to give you an outline of the process for expunging your police record and your court record. It's not a particularly complicated process. I will send you after the webinar an instruction sheet, as well as all the forms you need. All of that is on our website, but I'll send it to you in the email. And I'm just going to give you sort of the bird's eye view of it today. So what is an expungement? An expungement is when you have been accused of a crime and been convicted of a crime, and you want that crime removed from your record. It would be removed from your police record and removed from your court record. Those records aren't destroyed, but they are sealed. And they are very difficult to access, partly because it's impossible for an ordinary person to discover that they exist at all unless you tell them. So once the charges are expunged, it's like it never happened before. The only place the record exists is with the state police under seal. You can't have all convictions expunged in Virginia. We have a select few that can be expunged, and those include cases where there's been an acquittal, where there's been a null prosequi, which means that although the charges were filed, the prosecutor opted not to prosecute and dismiss the case. An outright dismissal of the case, a absolute pardon from the governor or other governing person like the president, pardoning you from the charge of which you're accused, or your identification was used without your consent. So that would be a situation where someone says, yes, I'm John Smith. He gets convicted, but he wasn't actually John Smith. He was Mike McCarthy, all people I'm related to and all totally believable. But that is another situation where you can have the case expunged, even if it was a conviction. So again, once the case is expunged, it disappears from the public court record. I can't access those records anymore. It exists only at the state police level, where it's sealed for a period of 3 years. After 3 years, all data related to that case is destroyed, and it's like nothing ever happened. So how do you get a case expunged? Step one is to go to the circuit court where your conviction took place. So if it's in Prince William, Manassas, or Manassas Park, that would be our court. If it's in another jurisdiction, unfortunately, you have to go to that jurisdiction to have the case expunged. But you fill out a petition form, which I will provide to you, as well as a proposed order, which I'll also provide to you. You follow the instructions on the form, fill out what charge it is that you want expunged, indicate what the final disposition was. Was it an acquittal, dismissal, or null pros? And follow the instructions for how many copies need to go where. There is a filing fee of $98. That includes an $86 statutory filing fee plus a $12 service fee. That service fee pays the sheriff's office of the jurisdiction to serve the Commonwealth's attorney with your petition. At that point, the Commonwealth's attorney for your jurisdiction will review the petition, and either they'll say, I have no objection to this expungement. I have nothing to add to the record, and allow the judge to then just expunge the case. Or they'll say, we do object. Reasons for objecting most commonly are because the underlying case didn't fall under one of those umbrellas of acquittal, null pros, or dismissal. That's the most common objection we see. So a little work on the front end to make sure that your read of the record is correct will go far. While the Commonwealth's attorney is reviewing your petition and application, we, the clerk's office, will provide you with a fingerprint card to take to the state police. You can go to any state police barracks and have your fingerprints taken there, and then we will forward them to the state police. The purpose for that is for background checks. A background check will be done and provided to the Commonwealth's attorney when they're making their determination as to whether they're going to object or not object to your expungement. So once we get the fingerprints back from state police, we get the answer from the Commonwealth's attorney's office, then you're docketed on the 9 o'clock docket on a Friday, and the judge will either grant your expungement, or they'll hold a hearing where the Commonwealth's attorney says yes or no, I object or I don't. You get a chance to argue your case, and then the judge will make a ruling of either expunging or not expunging. Then there is a smaller portion of the cases that we see, which are absolute pardon expungements. So if you get a pardon from the governor or a pardon from the president, and you want that criminal record removed from your court records and your criminal records, there is no filing fee for that because the court considers you innocent. And the process is much the same after you make that initial filing, but you don't have to pay the $98 filing fee. Then there's another consideration at the moment. The legislature passed new expungement laws in 2021 that go into effect in 2025. It does change the process. In some cases, it may be more difficult to get an expungement. So I would encourage you, if you're thinking about getting an expungement, do it now rather than later. That is not legal advice. I'm not permitted to give legal advice, but the change is coming. One good thing about that change is that you will see automatic expungement of certain drug crimes relating to marijuana. If you have a conviction relating to marijuana, you should look into the details of that. Some of those offenses will be automatically expunged. You don't need to file, you don't need to make your case, pay the fee. They will be automatically expunged, but that expungement is not required until 2025. So if you are looking at you're graduating from college, perhaps, and you have a conviction for marijuana and you're going to be looking for a job in the next year, it might behoove you to file, pay the fee, make sure it's taken care of in a timely manner. The other thing is that if the expungement is in fact processed or automatically processed by 2025, relies solely on your clerk of court. So if they don't have the resources or the abilities, or there's just been an error made, and for whatever reason, your file wasn't expunged, it'll still be out there. There's no guarantee. So you need to take a look, make sure, do your due diligence, make sure that that expungement does happen by 2025. And if it doesn't, bring it to the attention of your clerk so that they can cure that problem. But my number one recommendation is don't let it wait. Things change. Not having your case expunged can affect your prospects for housing. It can affect your prospects for employment. Sooner is better. It gives you a better chance of succeeding as you re-enter sort of normal life. I will be hanging around for any questions that you might have. And again, I'll send all of this information along with the forms and some instructions at the end of the webinar. So thank you.
Thank you, Jackie. We appreciate your contribution to this webinar. So up next, we have Christopher Alvarez with our Office of Elections discussing restoration of voters' rights.
Good evening. My name is Christopher Alvarez. I'm here for the Prince William County Office of Elections. If you give me one moment, I will go ahead and get this going. So in restoring your rights, one of the things is what we do here in the Office of Elections. As you can see, we are responsible for registering the voters when there is elections coming up. If you were to request a ballot to vote by mail, we also do those. And we also have the in-person voting for both early voting and election day. Our officers are always assisting at the polls, and if there's any other questions, of course, you can ask them or our staff here. Now, the importance of reinstating your rights, what are they? In the following, you will be granted these is the right to vote, which is very important, not only for me, but for everybody here. You will become a public notary public, where you can notarize. You can serve in a jury, and you can also run for office. Now, all this I got from the information in the Secretary of the Commonwealth website, and that will be in the presentation as well. If you're more than welcome to use that. Now, in reinstating your rights, you're going to go to the Secretary of the Commonwealth website, which I have the link here. It'll look something like this over here, where you can see it. Where you want to go is to the Restoration of Rights tab. From there, you will click on Request Your Rights to be Restored. And please note that if you're not sure, if you've already been convicted of a felony and you're not sure that your rights have been restored, you can also check the status of your civil rights tab as well. Now that will open up to where you can insert your information. You're going to enter your first name, your last name, as you can see here, as long as with your date of birth and your last four of your digits of your social security number. Depending, once you enter that information, it'll either give you a record that'll be found, which is on the information. And right here, you can see that if there is a record, you will see your information down at the bottom. And depending on your status as well, it may vary from ineligible, depending, and granted. Now, if your status is granted, it will also give you a little tab down at the bottom where it register to vote. If there is no record found in the website, you can see here, it will give you the right over here on the right side, no record found. I would contact the Secretary of the Commonwealth for more information. Here at the office, we're not sure. I'm sorry, we're not an investigative office where we are finding out what's going on and why you've been convicted of a felony, not to give too much information. We only know is if the only way we're informed is once you register to vote and we go ahead and enter your information in our system, is that once a prohibited match is popped up, it will give us what's called a felon match. And we basically go off of this website that I'm going off right now, which is the Secretary of the Commonwealth, to see if your rights are restored or not. Now, if we find no record, that will prompt a denial. And if we do find a record and if it's ineligible or if it's pending, we will still have to deny that registration and send out that denial notice out to you. Our information is, our contact information is right here if you have any questions, and I will also hang around for the last few minutes of the webinar. If you have any questions, I will answer those to the best of my ability. And I also have the Secretary of the Commonwealth information. Now, let's see here. If you are trying to reach out through email, if you see down here, email the Secretariat, you will have to be communicating with the governor's office and putting down some information down here. So that's basically what's going on here at our office is we make sure that if your rights are restored and we still find the felon match, we go on to the Restoration of Rights website, as you can see there. And if it's granted, we go ahead and take off that we don't take it off, but we go ahead and restore your rights from our system. And that's the Office of Elections and what we do here and how you can restore your rights.
So thank you, Chris. We appreciate that information. And again, thank you for being part of this webinar. Next up, we have Mark Cherninsky from the Virginia Career Center, and he is going to talk about employment resources and a reentry program that the Virginia Career Works has to offer. Thanks, Mark.
Mark, you're muted.
And Mark, you're muted, and you are sharing your second screen. Mark, can you hear us?
Okay. I'm gonna, when in doubt, try again, right? There you go.
There you go.
Okay. That's better. Here we go. Thank you for your patience, folks. Yeah, so my name is Mark. I'm a job developer with Virginia Career Works Northern Region. We are the employment agency for the Fairfax, Prince William, and Loudoun County region of Northern Virginia. And we have operate as the employment centers in the region, including the one on Minnieville Road here in Woodbridge. Thank you for your time tonight. I particularly focused for the last 6 or 7 years of the 10 I've been with Virginia Career Works in working with folks who have a criminal background as a barrier to employment. We also work with folks who have maybe just been laid off or they're underemployed. We have free walk-in centers, and I'll be talking a little bit about that too tonight. And some of the things we do to work specifically with folks that have criminal backgrounds to overcome them and as they re-enter. So here we go. That's me. Virginia Career Works. So we have the center. We have several centers in the region that are, I like to describe them as antennas for the job market, and they are connected more in obviously in the immediate area that they're in than anywhere else. But we share job leads throughout the region with each other. So we're band together to get the word out about opportunities. So Woodbridge doesn't have to go to Leesburg to get the buzz. They've got coming in by email and other sources on a real-time basis, and vice versa. So our services are free and open. Folks can walk into the centers when they're open during their hours and check out a computer or make copies of the resume or peruse our job leads. I call it the DIY level, and there's also an intensive level where you enroll in a program to get assistance with your transition from one job to another or from unemployment to reemployment. Our centers are in from Woodbridge to South County in Alexandria and Cherokee Avenue on 395 inside the Beltway, Annandale inside the Beltway, and Leesburg. We also have presence of some folks that are case managers in our anchor program we call Workforce Innovation Opportunity Act, and they're based in offices in Fairfax County Government Center with Department of Family Services, as well as in Reston in the Lake Ann area. And so you might see, might hear information about folks and employers and things of that nature from those regions as well, or those parts of the region. So these are our basic career services. There's what I call pre-employment services, helping you with your resume, helping you with job, brainstorming employers, brainstorming possible other alternative job titles that you might want to search for or tracks you might want to pursue, doing assessments to determine which ones are more appropriate next steps for you. And all of these services are free for folks that enroll in our programs. The coaching is also part of it in the terms of coming from a case manager in the programs you might get involved with. And most of our programs will, if you're eligible, you can enroll in even in more than one, and all of them come with certain some, not just a person to help you, but also quite often money to assist you through training to get perhaps like a credential or take a class in an area that you have expertise that you might want to upgrade your skills to connect, to be more competitive in the job market and have a little more confidence, and also to make your story a little more positive when you're interviewing and networking. Access to education and training options is one of the things that folks often come in there. Now, if you wanted to drive a dump truck, or you wanted to be a radiologist technician, or you wanted to be advanced yoga instructor, I wouldn't train you to do that. We have 60 some training providers who are signed up with us and have classes that they offer, professional vocational classes, and they're the experts and we've enlisted them, and we're looking for more, by the way. So if you know of anybody out there that's looking that offers some training that's credible credential, please have them take a look at our website. That information will be at the end of my presentation. Resume assistance is actually, I wanted to say this before I get ahead of myself. Resume is never done these days, thanks to technology, Microsoft Word, and so forth. You can change your resume for every job and in every instance of a job you're pursuing, and I strongly encourage that to folks. So keep your eyes and your ears open, and keep your mind open to tweaking your resume. It's an art these days, and it's a lot of fun to really craft a good resume and cover letter to an application for some jobs to prepare for it. So learn to really enjoy that. In the case of folks with backgrounds, accounting for your gap in your work history, however, becomes, sometimes it's an art, sometimes a little more than an art, to determine what you may have done with the time while you're incarcerated, if you had a trustee role or not, and we can talk about that and try to reframe that, and or the employer that you worked for, being the institution when you're incarcerated. Those are some of the easy ones. The other ones are, when it comes to your resume, might want to tweak it into instead of a chronological resume, into a functional resume, so that we highlight your strengths, and including perhaps the training you might be going through and its relevance to the jobs that you're applying for. Job lead assistance, I can't stress enough the role of the centers and the people in the centers as antennae in your radar for your job search. We have emails all day long from funneling in throughout our region of job leads from our case managers and our job developers, from, like I said, from Leesburg to, frankly, to Quantico. Good network, good resources to lean on. Interview preparation clearly is something that we offer everybody when it comes to folks with a criminal background. Preparing for the interview includes, discussing and disclosing and explaining your record to your employer, if that's applicable or appropriate, and also talking about or offering them the federal bond program and the work opportunity tax credit, which are incentive programs that are offered through their federal programs for employers to incentivize them to give folks a second chance, and that might have a criminal, a felony or more multiple felonies on their record. And we, and they actually, I would say, like a method I try to teach folks to utilize that as part of their explanation of their criminal background and their transition to the community, and the assistance they're getting from us and other folks in the family or church or things of that nature. And the obvious evidence is the letter saying, hey, we provide this incentive to employers to motivate you to give our the team to give them a second chance. We can talk more about that on a case-by-case basis and when you look me up. So there are other programs that folks typically take advantage of in the community, and that are, we call it social services or family services. The SNAP Employment ET program is a SNAP Employment and Training. And that typically, I think it's administered at county level, Prince William, Fairfax, Manassas Park. And they typically have some employment and training money set aside as well for people who, I guess, volunteer to participate in that. And the VIEW program is Virginia's program for transitioning from TANF, temporary aid to needy families, into employment and self-sufficiency. They often have some money for folks who are transitioning from unemployment or underemployment and from the TANF program, so they can utilize that for support services like transportation and in I think SNAP and View's case, or childcare, or even sometimes even minor repairs on a car or something to help you get to work, or interviews and things of that nature. So we bundle them together and on a case-by-case basis, work with you and your other case managers to leverage those resources to, help you keep those distractions out of your way so you can focus on that job transition. And that's really what we're here for. And I've seen some, you'd be surprised at how much we are actually thinking about those things a couple of steps ahead, and look forward to helping you. The Senior Community Employment Program and Ticket to Work are two other employment programs. One, the CSEP, the Senior Community Employment Services, is for folks who are seniors. I think 55 and over is how when you'll be eligible for it. And Ticket to Work is for folks who might be receiving Social Security disability income. Workforce Innovation Opportunity Act actually is our anchor employment and training program with our agency, and it's usually what we model our programs after, like my ESLA program. ESLA, we like I've described, we have case manager and money for training, and up to a year's worth of case management to assist you with that. Then the federal bond program and work opportunity tax credit we've discussed. So these are just some of the tools that we use to help you anticipate and overcome barriers as you're reentering. Here's an image of our website. You can get more information. We actually have a page on our website focused on reentry services. And this is one of our partners I like to talk about with respect to reentry and expungement. There's a regional local service of Northern Virginia. I believe Vincent might even be here today on the call. And they're a great resource for folks who are reentering and will have questions trying to overcome their expungement in the region. Thank you very much for your time again. And if you have any questions, I'll be here at the end.
Thank you, Mark. Again, we appreciate the information, and job resources are really important, especially for people that are trying to reenter.
Kimberly, you're muted.
Mark, thank you so much for that information. It's really important that we let everyone know that there are job resources for people that are trying to re-enter the community. Thank you. Up next, we have Mindy Weinstein, and she is the director of EEOC, our DC field office, and she's going to discuss employment and arrest records and the application of Title VII in that. So thank you, Mindy.
Thank you. Well, I think as you heard from Mark, the implication is, and I think the reality is, that for people who have arrest and conviction records, it can be a barrier to getting work. And to some extent, that may impact, that may intersect with the laws that the federal EEOC enforces, which prohibit discrimination in employment. So thank you for including us here. And I'm just going to talk a little bit about what EEOC does and how the anti-discrimination laws may be relevant to this discussion, and what people can do if they want to pursue a claim related to that. So let me not sure why I can't forward my slides here. Okay, So first, a little bit about what EEOC does, the place where I work. We enforce the federal laws that prohibit discrimination in employment, and our mission is to prevent and remedy unlawful employment discrimination. So it's in that context that I'm talking to all of you today. And while we are the federal agency, the folks who organized this in large part, the Prince William Human Relations Commission, they're a local agency that does similar work, and we work very closely with them. So a lot of this is going to overlap with cases that you could file either with the EEOC or with the Prince William County agency. So what types of discrimination does EEOC cover? Well, all the ones on this list: race, color, national origin, religion, sex, age, if you're 40 or older, disability, genetic information, and all of our laws prohibit retaliation. So I want to focus tonight on Title VII of the Civil Rights Act of 1964, which is the law that really was the first national law that covers discrimination in all these different areas that are listed here on this slide: race, color, sex, national origin, and religion. This law was created really as a result of the civil rights movement's fight for equality in the 50s and 60s, and the effort to get legislation passed that would outlaw race discrimination and other types of discrimination in a whole range of different areas in American society, from hotels and restaurants, federal funding of things, and Title VII, or Section 7 of that law, had to do with employment. That law also created the agency where I work, the EEOC, and gave us authority to accept charges and investigate charges of discrimination. The entities that are covered by this law are through any entity in the country that meets this criteria. Any private sector employer, whether it's a a restaurant, a hospital, a security company, a high tech company, any employer that has 15 or more employees, and that includes nonprofit agencies, state and local governments, employment agencies, staffing agencies, temp agencies are all covered. Unions are covered. The federal government is covered, but there's a different process and a few different rules. So I'm really focused instead on, for tonight, on private sector. Although, a lot of what I'm talking about would apply in all of these contexts. Title VII, in outlawing discrimination in these various ways, applies to all aspects of the employment process, from recruitment and hiring to what you pay people, what work you assign them, who you promote. It covers harassment, like sexual harassment and racial harassment, discipline, and all the way to discharge. So really the whole gamut of employment. Among other things, this law, Title VII, prohibits discrimination in two important ways that are relevant to what we're talking about this evening. One is it prohibits discrimination, what we call disparate treatment, which is, like it sounds, treating people differently based on one of these criteria: race, sex, color. So if an employer says, well, I'm just not going to hire people who are Black, or I'm not going to hire Hispanics, or I don't think women should work in this kind of job, or I'm going to pay a woman less than this other person, than a man for a similar job, then all of that is disparate treatment. It's just biased behavior that is treating people differently because of one of these protected bases. Title VII also prohibits discrimination where there is a disparate impact. So there may not be like a direct bias, like I don't want to hire a person of that religion or that race, but they have a neutral seeming policy that actually has a disparate impact on a particular group. So, for example, if an employer said everyone who works here has to be at least 5'10", that would, as you can imagine, screen out a whole heck of a lot of women disproportionately to the number of men that it screens out. So that's an example of a disparate impact type case. So how does all this relate to reentry and the impact of arrests and convictions? Well, under Title VII, there isn't a rule that says an employer can't obtain or use criminal background information, but there is an expectation that this information be used in a way that is not discriminatory. So again, looking back at this disparate treatment and disparate impact analysis, if an employer's treating people differently who have similar, the same type of criminal records, and they treat a person of one race or sex differently than another, then that could be an example of disparate treatment. And similarly, if they use a policy of excluding people based on criminal records that disproportionately excludes people based on race, color, sex, and the other types of discrimination covered, then that could also be a violation unless the employer can prove that excluding people for this reason and using this criminal record check is job related and consistent with business necessity, which is the legal standard. And I'll talk about what that means in a minute. So let me just give you two quick examples. In a disparate treatment case, let's say a Black person and a white person apply for a job at an office, both have marijuana possession and distribution records. It could be any crime, but okay, this is what we picked for this example. The employer hires the white applicant, but not the Black applicant. So unless the employer's got another really good reason, because we just said these are equally qualified people with the same conviction record, then that very well could be discrimination against the Black applicant. And so we're going to look to whether they're treated differently, whether they have the similar background, et cetera. We also may find evidence that the hiring official was, made biased statements, like maybe said about the Black applicant, we don't want these drug dealer types here. And about the white applicant thought, oh, I'm sure he's learned from his mistakes. So there sometimes is direct evidence of bias like that that would help establish a claim of race discrimination. But even without that, we would look to whether, there was discrimination in treatment. So now let me talk a little bit about a disparate impact example. Let's say there's a company and new ownership comes in and says everybody who works here is fired and everyone just needs to reapply now for their jobs and we'll decide who to hire. And in doing that says, hey, we're not going to hire anyone who's ever had an arrest or a conviction. These are actually based on real cases. So that criminal record policy, we're not hiring anyone with an arrest or conviction, quite likely will disproportionately exclude people based on race and national origin. We know from national data that their criminal record exclusions have a disparate impact based on race, particularly in the African American community, and based on national origin, particularly the Hispanic community. And all of this affects African American men and Hispanic men the most. They are arrested, convicted, and imprisoned at a much higher rate than other people. So if you have if an employer has an exclusionary rule like that, then it very well may have a disparate impact. And we would look at national data, of course, but there might also be local data. And the employer itself, in this case, may have data on who ends up being able to get hired with the new ownership and who doesn't, based on this criminal record review. I mentioned that the employer's defense to this is that they would have to show it's job related and consistent with business necessity. That's the legal standard. What does that mean? Well, there was a case about in the late 70s that called Green versus Missouri Pacific Railroad that involved this exact issue of a person with a conviction being excluded. And the court kind of laid out three factors that an employer needs to consider in making a decision. It really, and to have a blanket, we're not hiring anyone with an arrest or a conviction, is quite likely to be illegal. But essentially, employers need to look at certain criteria: the nature and the gravity of the offense. What was the harm? Was it a harm to property? Was it a marijuana crime, or was it a a personal crime involving a domestic situation? Was it a violent crime? So you're looking at the nature and gravity of the offense, how long it's been since the offense occurred, since the person was convicted, since the sentence was completed, because I think, studies show a lower chance that people repeat crime if as time goes by. And also, very importantly, the nature of the job that we're talking about. Okay, so is this a job that is um, working with children and the person was convicted of child abuse? I mean, that's probably going to be a very valid reason for an employer not to hire that person. But if the crime is, a drug crime and it's working at a environment that is, an office environment, a warehouse environment, that might not be a valid reason for an employer to exclude someone. So you're looking at what was the offense, how much time has gone by, and what is the job? And how do these things intersect? Are there vulnerable people the person would be working with? Are there, if the crime was stealing cash, maybe they don't get a cashier job, but maybe, some other type of job. So these are the kinds of factors that are looked at, and we really expect employers to do an individual assessment of this. Okay, so all of this means that there might be the possibility that if a person is excluded from an opportunity to get a job, or sometimes it's get a promotion, because of a criminal record background, you have the option of filing a charge of discrimination with the EEOC. You can also, as I mentioned, file with the Prince William Human Relations Commission or others. There are other state and local agencies in Northern Virginia. If it depends on where the job is. So if you live in Prince William, the job's in DC, you can file with us or the DC Human Rights Commission, or the Fairfax has one, Alexandria, Arlington. So there are opportunities to file a charge, and we're going to look at, was there a disparate impact? Was there a disparate treatment? And, what does the data show, and what is the reason given by the employer? You start that process at EEOC by going to the public portal that we have at eeoc.gov. There's a lot of information about how to do that. There are deadlines for doing this, so keep that in mind. For most of the DC area, the deadline for filing a charge, meaning actually signing the charge, getting through the entire process, is 300 days. But there are some employers that are have a deadline where the deadline is 180 days, and those are employers where they're covered by EEOC only and not Prince William's agency or some of the other state or local agencies in our region, and that includes the metro system, and the folks that run the airport at National and Dulles. So anyway, you got to figure out what your deadline is. There's information on our website. You can call our office. You can access our system by going to eeoc.gov. You set up an email account. You respond to some questions online. You can schedule an intake interview. You can upload documents all through this online portal. If you can't access us through the portal, reach out to our office directly. We have a phone number on our website. You can contact me. You can contact my colleague, Monica Kalunga, who's on this call, and can, I'm sure, put her info in our chat. So then finally, just a quick overview of what's going to happen next. If you file a charge with us, we're going to send the charge to the employer. In most cases, we will invite both the person who filed the charge and the employer to engage in a mediation effort. Sometimes we think right from the beginning that there is not validity to the charge. It's unlikely we would find discrimination and we may dismiss it. Some cases, not all cases, go to our mediation department, but most do. If it doesn't go there, or it doesn't settle there, we'll get a response, a position statement from the employer. We would share that then with the person who filed the charge and invite them to submit a rebuttal to the position statement, so the employer will explain, hey, this is why we didn't hire the person. And, the individual who filed the charge would have the opportunity to respond. We may conduct additional investigation. We may go obtain additional documents. If in a case like this, we might find out, how many people were affected by it, who was screened out by a conviction screen or a arrest screen, and get information of their race or national origin, et cetera. And ultimately, we try to resolve it, possibly through a settlement. If we don't believe there's sufficient evidence, we would issue a dismissal and the person can go to court directly. If we find that we believe it's more likely than not that there was discrimination, we would issue a letter that basically describes why we think that is the case. We would attempt settlement at that point. Again, That's called conciliation, but it's basically an opportunity to try to resolve the matter. And if we can't, and we get through all that entire process and we're unable to resolve it, we may file suit in federal court on the matter. So that's a quick overview of how our laws intersect with the issues of the impact of arrest and convictions as people try to get jobs or get promotions. We have a whole guidance document on our website. This is the name of it. If you type in arrest and convictions and at our website of eeoc.gov, you will find a lot of materials on this and further information. I mentioned Monica, my colleague from the Washington field office. She does a lot of outreach and education on this issue and many others. So if you want to reach out to her with some questions, or you're an employer and you want some more information, or you're from an advocacy group and you want us to come and talk, we're happy to do that. Feel free to reach out to Monica or let us know through the chat right now, or reach out to me as well. So I think that's it. I'm going to end my slideshow and turn it back over to Kimberly.
Thank you, Mindy, for all of that information. We appreciate your participation. And so we do have a couple of questions in the chat. Chris, so we have a question for you, and one of our participants wants to know, how long does the reinstatement process take?
So that process takes about a month or 3. Looking at the FAQs from the Secretary of the Commonwealth, I'm not too well versed on what they do over there at the office. I will have to contact them most likely and get a little bit more information. But yeah, from the frequently asked questions, it's about 1 to 3 months after the individual has requested for their restoration of rights to go through.
Okay, so 1 to 3 months. Thank you.
Mhm.
Mark, we have a question in here for you as well. Can you see that question, Mark?
Yeah, regarding ban the box.
Yes.
Yes, Carol's question about ban the box. So yeah, Carol, thank you for your question. So she wanted to know if I counsel folks about ban the box, and do I discuss it with them? I do. It definitely comes up. It's a very it's a desirable trend, and a lot of I think the Commonwealth and county agencies in Virginia have adopted ban the box with some exemptions for some agencies that have law enforcement or financial or medical twist that and where they have basically we call maybe barrier crime still for things that are more specific. Well, probably would be described as like savvy matches or mismatches for different charges. A lot of employers have also implemented ban the box. One of the challenges that unfortunately, that candidates have too, though, is that when they're going through the process, they've been incarcerated. They're anxious and ready to get to work, and it does delay the process if background check ultimately is still going to be done and gonna end their candidacy. So I often counsel them to be proactive and to try, if an opportunity presents itself, to own their story and explain it before a background check comes back and squash it, because they can turn the interviewer or interviewers into champions for them, in a good sense. And in a bad sense, the interviewers might say, thank you for your honesty, that we're probably going to have to end it here. And that's sometimes a reality, which way they could probe further if they think that's not enough. But I don't know. But the ban the box definitely is a very positive and desirable trend.
Thank you, Mark. And I'm sure Carol thanks you as well. She'll probably be in touch with you after this webinar, right, Carol? And Jackie, we have a couple of questions for you here. Can you see those questions?
Yes.
Okay,
So
okay.
the first question is from Sheila, do you recommend an individual have representation for this process? So that's always going to be a personal choice based on your resources, your level of comfort in the court. I will say I was a practicing attorney before I became clerk. I was elected clerk. And I would have never advised any of my clients to do it themselves. That doesn't mean you can't do it yourself. But Mark touched on Legal Services of Northern Virginia. They're a wonderful resource. I'm probably biased because my husband's one of their legal aid attorneys, but I think they're just great. We also have the option, and I will send it to you in the email, that our Bar Association offers a free referral service, or not free, it's not free, it's $35. But that $35 gets you 30 minutes with an attorney who practices in the area of law that you want. I would at least do that. It's worth the $35 to talk to someone who can advise you about expungement. Unfortunately, I can't give legal advice in my current position. The other thing is my office, in conjunction with the different elected officials in the community, we run expungement fairs periodically. We have one coming up in Dumfries, April 22nd. It's being sponsored by Vice Mayor Nickerson and Councilwoman Miles. It's at the Dumfries Rescue Squad, and it's a one-stop shop. You come in, you have your police record pulled, you go, you talk to the Commonwealth's attorney. The Commonwealth's attorney does her thing, sends you to me. We do our thing. We send you to, in this fair, it will be the Dumfries Town Police. They take your fingerprints and you're done. You just have to wait for the judge to take a look at it and make their decision one way or another. Again, the next one is April 22nd. I'll include the details in the email. Just be careful. We do need pre-registration by April 8th to allow the Commonwealth's attorney to take a position on the case. And if you're not going to do the April one, but you might be interested down the road, I will send you our social media handle. That's the best way to get the new news from us. We advertise everything we're doing on our social media. The second question is, how long does the process take? The process before it gets to a judge takes a couple of weeks. Depending on caseloads, it can take the judge 3 to 6 months to sign the order. Once the order is signed, we expunge the record. We tell the state police to seal the record and schedule it for destruction. And if your expungement's been granted, at that point, we issue you a refund for $86, which is the filing fee. So you do end up losing the $12 for the service fee to the sheriff's office. But I think you'd probably agree that you got some value for that. And then how can an individual check to see if a conviction is expunged? I will provide a link to the Virginia court case information. The vast majority of courts, both the lower court and the circuit court where I am across the Commonwealth, are on that system. And you can now do a cross-county search to see what records exist out there for you or in your name. That's important too. The most notable court that is not included in the online access system is the Fairfax Circuit Court. For them, you would have to go call them or go into the office and ask for a copy of your record. Those aren't available online to the public. Then if a misdemeanor conviction is over 7 years, can an individual apply for expungement? It's harder because, and for those in the meeting who aren't familiar with this 7-year benchmark, that is when records can be destroyed in certain circumstances in certain courts. So you need to reach out to the court and see if they have the record to expunge. And we have a question about an arrest at the Black Lives Matter I'm blanking, but I don't want to say the word you used. The word I'm looking for, the Black Lives Matter protest. So in this situation, the case has been dismissed, and the question is, will the charges still come up when the police search my name? So the answer is yes. It will come up that you were arrested and that the charges were dismissed. To have it not come up on that roadside check, you need to file for expungement. Where the case was dismissed, barring any extraordinary circumstances, I would say you probably are in a good position to get that case expunged. And then once the case is expunged, it's like it never happened. So if you are in a situation where you're asked, have you ever been convicted of a crime? They don't usually say convicted, they usually say charged. In the eyes of the law, you could probably say no. I would ask an attorney if that's their position, because again, I can't give you an opinion, but it's literally like those charges and that arrest just never happened and never existed in the eyes of the law. So you would still need to file, but that would be a great one to take to an expungement fair because it's easy.
April the 22nd, right, Jackie?
Yes, and again, I'll send that along. There are also probably some attorneys locally who would take that case pro bono and help you out. But the expungement fair is the easiest.
Thank you so much, Jackie. And we've run out of time, everyone. So thank you for attending our webinar today. We have shared a wealth of information, and it is our hope that you'll contact us in the future regarding any questions related to reentry in Prince William County or anything that you have heard today. And following this webinar, again, we will send out all presentations, handouts, and information to complement everything that was presented by email. And lastly, look out for any future webinars from the Prince William County Human Rights Office. So thank you so much for joining us this evening.